Hello, I'm Christina Presenti from the National Sexual Violence Resource Center, and I'm happy to welcome you to the webinar Confidentiality for SARTs. This webinar provides a deep dive into confidentiality and privacy related to supporting victims and working as a team. This is one of many webinars you can find in the SART Toolkit at www.nscrc.org/SART and in the SART webinar series. The SART webinar series will be available on YouTube. We would like to thank the Office for Victims of Crime for their support and funding of this webinar and the entire SART Toolkit and additional supplemental materials. We would also like to offer the disclaimer that the opinions, findings, conclusions, or recommendations expressed are those of the contributors and do not necessarily represent the official position or policies of the United States Department of Justice. I'm really glad that our presenter, Sarah Layden of the Confidentiality Institute, could join us today. And we'd like to turn over to Sarah for their introduction and their presentation. But again, I just want to show you the website. And again, that's on the screen right here, www.nscrc.org/SART-Toolkit. With that, I will hand it over to you, Sarah. Thanks so much for joining us today.
Thank you. Hello, everyone. My name is Sarah Layden. I am an associate trainer for the Confidentiality Institute, which is a technical assistance and training program that helps nonprofit organizations, government agencies, and educational institutions to solve confidentiality challenges. I'll also add that I have been doing sexual assault victim advocacy work for the last decade, where I'm a director at a rape crisis program located in Chicago, Illinois. I participate in a multidisciplinary team like a SART, and I know firsthand how tough confidentiality can be in these spaces. Keep in mind as we have this discussion about confidence within SARTs that we are talking about confidentiality, which is a big umbrella. Individual jurisdictions should be aware of exceptions to confidentiality by profession, victim characteristics like age, emancipation status, competency level or disability, and applicable state or federal law. It is up to each SART to dive into their local circumstances and implication for various victims. The SART Toolkit, as mentioned, has more resources and tools for SARTs to access the information locally. And with that, let's dive in. I would like you to think of all the reasons why confidentiality is important to our clients in our daily work. Aside from ethical and legal obligations, which we will get into in just a moment, confidentiality increases victim autonomy, emotional and physical safety, as well as decreases personal or societal consequences such as discrimination at work or alienation from family or community. Because they can control who and how the information they share is used, this increases the likelihood that victims will seek support and fosters the restoration of control in their life. But what exactly is confidentiality? Confidentiality is a general umbrella term for how we conduct ourselves and our services with the sensitive and private information learned from our clients. It is helpful when thinking about confidentiality to break this down into three concepts: privacy, confidentiality, and privilege. But first, what does privacy mean? This is the right to a personal choice, the victims in this situation, on who and how much information to disclose. The survivor decides what information they want to share and with whom about the harm that they have suffered. This is similar to the decisions we all make daily about who and what we share about our personal lives with others. I may be comfortable sharing something private with my best friend per se and not a coworker. Even with friends and family, there may be things we intend to keep private from them and everyone. Victims determine the privacy of their information. They navigate this in every communication with what they feel comfortable sharing. Second, confidentiality, again used as an umbrella term for these concepts, is the responsibility, typically legally or ethically, to protect someone else's privacy. The professional, in this example, you as the advocate, has this duty. Confidentiality means you respect the victim's choice about whether to share information, which means you share it when the victim asks you to do so, and don't share it if you don't know what the victim wants. Last, privilege. often used interchangeably with confidentiality, is a legal rule of evidence prohibiting the disclosure of private information against someone's will, meaning that there is legal standing that no one can make you share information without the victim's permission. Some states have privilege codified in statute and others do not. Even if you do not have privilege to fight, say, a subpoena for records, you still have a duty to keep information confidential, which means you always need a survivor's permission to share any information about them. Without privilege, however, you do not have a legal rule that protects disclosure of private information against the victim's will, but you still have an ethical duty to protect the information. This includes even confirming or denying that someone is a client. In SARTs, the benefits of confidentiality to victims also exist with regard to safeguarding client information. In addition to fostering safety and autonomy, confidentiality helps to assure appropriate exchanges of information that protect victims from exposure to systems they do not wish to engage in, or from scrutiny by providers who may not have trauma-informed, survivor-centered practices in place. Even with well-intentioned providers, confirming knowledge about a victim that the victim did not directly share with you understandably feels like an invasion of personal privacy. This is the case anytime anybody knows something about someone that they didn't hear directly from that person. For the providers on a SART, all of which have different access points to interactions with victims, maintaining client confidentiality increases trust of individual service providers engaged in sexual assault response. In turn, when individual providers are trusted, this can increase the victim's engagement with follow-up care, referrals to other providers, or engagement with other systems. In addition to the benefits to victims, nearly all SART team members have their own legal requirements on how and what they may share with other providers. As SARTs are newly forming, or even for SARTs that have operated for some time, it is important to have a clear understanding of each member's ability to share information and what this may look like in participating on the SART. The Violence Against Women's Act, Victims of Crimes Act, and the Family Violence Prevention and Services Act all contain strong confidentiality provisions that limit the sharing of victims' personally identifying information, including entering information into public records and databases. There is an exception where victim service providers share if there is a statutory or court mandate, an example, mandated reporting of child abuse. These provisions affirm confidentiality practices that protect the safety and privacy of victims of domestic violence, dating violence, sexual assault, and stalking. VAWA, the Family Violence Prevention and Services Act, and VOCA regulations prohibit sharing personally identifying information about victims without informed, written, and reasonably time-limited consent. Other entities on the SART have other rules or may even have other reporting obligations that could be triggered by SART discussions. An example, there's an exception to these rules for law enforcement and prosecutors that may be VAWA-funded on SART. In that, law enforcement can share information as it is appropriate for them to share to do their law enforcement job. That is not, however, an exception that victim service providers can share information with law enforcement. Additionally, medical providers on the SART have their own confidentiality standards under the Health Insurance Portability and Accountability Act, also known as HIPAA. In order to understand how to navigate confidentiality in a SART, it is important to set the methodology of your SART from the onset of its formation, as the exception of what information is shared varies on this intention. SARTs generally form in order to do minimally one of three things, and sometimes even all three. In a case management SART, SARTs engage in conversations about open cases in order to ensure coordination leading to timely and victim-centered response and investigation. An example, let's say that law enforcement responded to a sexual assault at a home they had been to several times prior due to domestic violence. And in the last instance, the abuser choked the victim who was pregnant after he sexually assaulted her. The victim lost consciousness and the offender fled. Providers meet to discuss the medical care provided to her, evidence collection, the follow-up of law enforcement in finding the abuser, the coordination of an advocate assisting in a protective order, and other needs such as shelter and new child care options for other shared children that are safe. Next, in a case review model, There is a review of closed cases from start to finish to identify gaps and successes of systems response, as well as measure effectiveness of interagency protocols. This can result in changes in policy, training, and procedures. For example, a review of a 2014 case is done in which a victim reported an assault to law enforcement and they did not believe her. A few years later, this offender's DNA hits to another evidence collection kit in CODIS, and he is arrested on the prior sexual assault. In the interim of him being arrested, he had nearly 3 other reports filed against him. The team talked about what occurred in the first report and in the latter reports, in addition to how the CODIS hit was obtained and how the case was charged and prosecuted. They discussed legal rules around multiple victims and the end guilty verdict, in addition to planning on how they could circumvent something like this from happening again. In a systems consultation model, this generally occurs when SARTs are reacting to the failure of a system to respond appropriately. This type of review can also lead to changes in policy, training, and procedures to improve overall response. These reviews generally don't need victim information as they are more focused on services received. For example, your prosecutor's office discusses a few cases where there was a suspected drug-facilitated sexual assault and how no urine sample was obtained by the hospital staff, therefore hindering meeting the burden of proof at trial. Whatever the method or intention of your SART, this should be laid out from the onset in an effort to decide what and how information is shared in these spaces. Confidentiality and navigating it occurs daily in doing advocacy work. Acting on behalf of our clients is the essence of what we do. Navigating this can be tricky. It is easy to pay attention to confidentiality for task-oriented work, such as getting a case update from a prosecutor or working with a hospital to schedule a follow-up appointment. What becomes complicated in SARTs is how to navigate legal and ethical obligations while maintaining effective advocacy to improve response to victims. Not all professionals on the SART team will be confidential professionals. In fact, some very much will not be, like law enforcement and prosecutors. The trick in a SART is having the confidential professionals respect that others will not come from a place of confidentiality and that they can still be survivor-centered. And for non-confidential professionals to respect the confidential professional's duty not to volunteer information. In order to do this in the most effective way, it is imperative that SART members abide by the following framework. Know first any state or federal laws that govern confidentiality. Remember, there is a difference between privacy, confidentiality, and privilege in individual state laws. Victims and partners must also be informed from the very beginning of engagement with you or any other system how the information they share will be used and or shared with others. This also means understanding other systems' confidentiality procedures and regulations. Keep this in mind while doing work with law enforcement, detention centers, schools, and hospitals. PREA, Title IX, and HIPAA may limit confidentiality, making access to confidential resources all the more important. Plan, how will those on the teams navigate confidentiality? When may potential breaches of confidentiality occur, and how can those be mitigated? How will you ensure service coordination in a case management model if you are not able to release information without written consent from a survivor? How will you do systems-based advocacy if signing a release could have implications on accessing your records later on? How will you share information with those on your team, like a prosecutor, that may be obligated to share the information with the defendant? These are all issues that need to be explored and resolved by members of your SART. This not only plans for safeguards on confidentiality, but also in ensuring that team members understand limits on what you are able to share and do not attribute these limits to lack of collaboration. In addition, it is important to plan who from your agency will be on the SART. Oftentimes it's effective to have advocates that have not had direct contact with these cases discussed be a part of the team to safeguard the potential for confidential information to be shared unintentionally. And lastly, pause. Pause before speaking in meetings and think about the above. How can you do effective advocacy while maintaining confidentiality? And don't worry, we have some tips for you in just a few more slides. To keep in mind what may trigger confidential information. Are you identifying the survivors of a certain race, community, or neighborhood? Even in SART discussions, there should be a member of the team that keeps an eye on potential confidentiality breaches and can pause the conversation when needed. Many people get confused and think if you sign a SART confidentiality agreement or MOU, that somehow changes what victim service providers are allowed to share without getting instructions from the victim. It does not. MOUs do not replace legal obligations of any SART member. MOUs should work to outline agency rules, regulations, and protocols around confidentiality and discuss how they will be navigated. Remember, confidentiality is an ethical and legal obligation. Under state and federal law, it is the survivor that controls who and how information is released. Additionally, under VAWA, a victim should not be forced to sign a release as a condition of service. This means that programs who aim to review cases on a SART should not implement the standard practice of victims waiving confidentiality. The group should also not get confused between a confidentiality promise to a victim, which includes not sharing information with the SART unless you have their permission, and the confidentiality agreement of the group, which means we are legally allowed to share in the SART. What we are legally allowed to share in the SART group stays within the SART group. As we discussed, there are legal exceptions to that group agreement, and even if the group itself is one of confidence, sharing information you are not able to is not protected legally and violates the victim's privacy rights. You can agree to keep the discussion of your SART private between the group members, but also keep in mind that this has no impact on your legal obligations related to your clients. Second, keep in mind confidentiality and turnover. People transition out of roles, and all SARTs should assure that protocols are clearly documented and discuss what onboarding and transition will look like when members transition into new roles or leave agencies. Note that consistent participation from the same team members are essential to the success of a SART, and transitions on who participates should be limited for the success of a team. These are difficult conversations, and establishing rapport and trust between members takes time, but it's also critical to the success of your team. Additionally, assuring that there is top-level support from each agency involved is also crucial to the SART success. I get it. Confidentiality can feel like a real barrier to true collaboration and genuine conversations with institutional partners, but it doesn't have to be. Partners that understand your role as an advocate will understand, with some education, the limits of what you can share, when, and how. Oftentimes you can convey what you need to without identifying information or sharing direct communication you've had with survivors. You also do not want to sign a waiver every time a case is being discussed in a SART. This can have implications to accessing your records later on. Specify which professions or categories of professions are impacted by which rules or the need to keep which things to themselves when establishing your SART. While setting the intention or methodology of your SART, choosing whether you're going to do a case review model, case management, or a systems consultation model, you also need to address what the expected outcomes or goals are of this process. Is the goal to change a charging decision or for police to make an arrest where they chose not to? Is the goal to increase overall arrest and/or prosecution rates or referrals to support services? Setting these goals is essential to managing the expectations of SART members, establishing the tone of meetings, and will determine how you communicate to your clients about the SART and to your partners. While increasing the efficiency of medical response, arrest, and prosecutions are essential to measuring overall success of SARTs, keep in mind not every victim may want to engage in these processes. What do SARTs look like for a victim who only wanted medical care? How are they linked up with services or provided information on how, when they are ready, if they are ever ready, they can engage in services at a time that's right for them? Additionally, setting the goal of changing charging or arrest decisions alone could create an adversarial tone to SART meetings. Again, while this should be measured as an outcome, a SART should have the overall goal of procedural justice. This is the idea of fairness in the process, which means ensuring that people are treated fairly, harm is reduced, options and information is provided, and choice is afforded. In setting the goal of your SART and having clearly explained processes and procedures, advocates are able to communicate fairly and accurately about their local SART to clients if this is permitted. This is an important decision that SARTs must make about the confidence of group discussions within the SART. Does the SART group confidentiality agreement allow or prohibit the advocate or any other professional to discuss with the victim what happened in the SART? The expectation and rules about this should be made very clear from the onset. If discussion with your client is permitted, be sure to explain the purpose of SARTs that aim to change an arrest or charging decision versus ones that are solely aimed to identify systemic issues for training or engage in case management coordination. If the intention of your SART is to change a charging decision, victims should be informed that their case is being reviewed for this purpose. Managing expectations of the outcome is also necessary. An example, you could inform your client that your local law enforcement office wants to discuss their case to improve systems response and inform training. You could ask your client how or in what way they may want to participate in this discussion, pending that this has been agreed upon and there is a clear protocol in place for how a victim may participate in this process. Remind your client that you will not share any information about them or even confirm they are a client if they do not want you to. It is essential to remind your client of their rights with regard to confidentiality, as well as Indian mandated reporting laws that exist. So clients are always making informed decisions about what to share, when, and with whom. Follow up with them about the outcome of the discussion if this is permitted by your SART. The sergeant wants to use your case in a training module. How do you feel about that? Or after a review of your case, the prosecutor is going to contact you about evidence they believe was missed. If a victim agrees that you may share information about their case, this must be clearly outlined in a time-limited written release. An example, say your client had a horrible experience with the responding officer or nurse and wants you to be able to share that's why they never called their detective back. You would need to assure the waiver includes the release of only this information. An example, you, the advocate, is authorized to discuss in case review on August 23rd with Dave Detective, Patty Prosecutor, and Nurse Nancy, the conversation had with Roger Responding Officer when he came to your local hospital on August 2nd. Assure you limit the time release. So for example, in this one, this would expire the next day, August 24th. Also assure your client understands the implications of this waiver and potential access to records later on. Even if a waiver is signed, you always have the duty to keep your client's information confidential. An important thing to remember about waivers of confidentiality, even when limited in scope and time, is that they may have implication on protecting records later on. Again, knowing the laws in your state will help understand the potential for these implications. There is a variety of ways to do effective advocacy without a release in a SART. Remember that it is often easier for advocates who have not had experience with a case to speak more broadly on issues. However, some examples advocates can use in SARTs or in their daily work include, you could address poor victim treatment by stating that in your own experience, and not a specific victim, follow-up from detectives takes weeks, which deters victims, or that you have had to repeatedly call a district to even find out who someone's detective was. Remember that names of detectives or nurses are also not important in these meetings. Look to the system and the process and identify your concerns related to that. Individual concerns about specific people and systems should be conveyed one-on-one with their supervisor and not in a SART meeting. You can also share generalities. If it is apparent to you that a hospital needs training, say, on HIV prophylactic treatment, you do not have to specify that the case being reviewed didn't have this offered if you know that. You could highlight this by saying, I'm noticing that HIV meds aren't documented in the medical record. Were these ever given? Knowing fully well they were not. After, you could mention that this seems to be a common practice from this hospital. Additionally, let's say you know your client has evidence that wasn't followed up on. This same approach may work. In the report, it states that this victim's sister was in the house, but I don't see a reference to her being interviewed. Was she? Or I see the victim's cell phone was scanned for evidence, but I don't see that the person who harmed them was. Was it? What prevented this from occurring? In closing, best practice in sexual assault, domestic violence, and stalking is moving more and more towards multidisciplinary teams and SARTs. In order to prepare for the way in which you or a member of your agency can participate in these efforts, understand state and federal law applicable to you and others on your SART. State coalitions are great resources for this. Take time to thoughtfully plan the goals of your SART and how you will achieve them with what you have discovered from your research. In addition, assure that there is consistency on who participates on your SART and implications on any pause moments where navigating confidentiality may be tricky. Contact others who are also experts in confidentiality and SART information. Additionally, remember that this training was based on the great resource created by the National Sexual Violence Resource Center and their SART Toolkit. Use it. I also have some other resources for you. The Victims' Rights Law Center has lots of resources for professionals on confidentiality, including their really terrific state-specific guides on privacy laws impacting survivors, which can be found at the link on this slide. The VRLC also has an OVW grant to provide confidential technical assistance to rural programs and legal service providers specifically, and can give assistance on any confidentiality questions. The National Network to End Domestic Violence and the Confidentiality Institute's Confidentiality Toolkit is also a great resource and provides a variety of tools and frequently asked questions directed at all VAWA, Family Violence Prevention and Service Act, and VOCA-funded service providers. The National Network to End Domestic Violence also has an OVW grant to provide confidentiality technical assistance to all OVW grantees and potential grantees, and can give assistance on any confidentiality questions. Sometimes I think that there's a misperception that the VRLC is the go-to for sexual assault providers, and the National Network to End Domestic Violence is the go-to only for domestic violence providers. The truth is they both provide excellent assistance to all anti-violence service providers. I've also included another resource for you on confidentiality and safeguarding it with online services and online documentation. And with that, Christina, I will hand it back over to you.
Thank you so much, Sarah. I really appreciate you being here to share all that information. I found it useful, and I certainly hope that this is a great resource for SARTs, for individual members, and to listen to as a team. I also appreciate you mentioning all those great resources where folks can go for technical assistance. Making those connections with technical assistance providers is huge. It's a great way to always make sure that your SART and your service agency has the most up-to-date information based on current best practices. And with that, I'll tell you again, NSCRC, or the National Sexual Violence Resource Center, is a great resource, is a good technical assistance provider, and our information is here. Again, the website and the link for the SART Toolkit is there. And we don't have an answer. We work very closely with a lot of other national sexual assault assistance providers, and we will be really happy to connect you with the great folks who would have that answer. And with that, I want to share with you Sarah and Alicia's information at the Confidentiality Institute. And Sarah, I'll send it back to you.
Thank you so much. Please feel free to contact me through the Confidentiality Institute if you have any other questions or need any more information about what I've shared today. You can email Alicia Aiken at alicia@theconfidentialityinstitute.org, who can put you in touch with me. Thank you so much, and good luck to each of you as you're forming your SART teams locally. Great.
And again, I just want to thank OVC for for supporting this project and remind folks that there is a whole webinar series that is part of the SART Toolkit. So hopefully you found this one interesting and informative. Please check out those other ones as well. And thank you to everyone who was here with us today.